Counsel.
Your Honor, we have a phone call that we would like to play. It states Exhibit 2-95D. We've laid the foundation for these calls through other witnesses.
We object. I think these phone calls need to come in through a witness, and I know this phone call is between two particular people, and they haven't admitted it through any witness. I think there will be witnesses coming up that they may be able to admit it through, but I object to it being played at this time.
Would you approach for me? Ladies and gentlemen, there's a couple of legal issues I need to sort out. If I sort them out now, it will make the rest of the day more efficient. I appreciate your patience. Please rise for the jury. Okay, folks, have a seat. We're still on the record. Ms. Lewis, I apologize for interrupting you. I think this would just be an easier way to have the conversation that we were having. Go ahead and complete your thought for me. Regarding jail calls.
Well, there's hearsay in this call also from the other party,
That will be true with every call. And so we'll need to come up with an instruction for the jury about how they are to treat the other side of each of these calls.
All right, well, I guess our objection is that these calls could and should be introduced through an actual witness. Playing them randomly, I think, is confusing for the jury.
May we stay focused on this particular call for a moment to tease out your position on that? So this is 2-95.
I'd like to look at that again, but I also think that we...
Hold on, I wasn't finished with my question.
I'm sorry.
My apologies. This is 2-95.
Yes, sir.
What was the number again?
2-95D.
295D.
Okay, so 2-95D, as I understand it, the state is seeking to play now because it relates to Ms. Richins having contacted Ms. Bramwell. Is that fairly stated?
Yes, Your Honor.
Okay. And so I think, as I understand the state's position, playing it at any other time than directly following Ms. Bramwell's testimony would be confusing. That's what I'm gathering from the state's position.
Correct, Your Honor.
Okay. So take it from there, Ms. Lewis.
I'd like to. I haven't looked at this call in a couple of days, so I'd like to look at it. But I also think by introducing these things without a witness on the stand is a violation of our Sixth Amendment right to cross-examine. When we introduce these randomly, we can't cross-examine anyone about these calls.
Well, are you talking about foundation or content?
I'm sorry. What was that?
Are you talking about cross-examining regarding foundation or content?
Content.
Well, the content, the part that's being admitted for the truth, is your own client's statements. So the confrontation problem doesn't exist there. And if we instruct the jury not to consider the other half of the conversation for the truth, there's no confrontation issue there either.
Well, if they were to call the witness, who is the other half of the conversation, and introduce the call through the witness, then we would have an opportunity to cross-examine regarding the phone call.
But not if the other half of the call isn't being admitted as substantive evidence. They're not admitting the other half of the conversation as substantive evidence of anything. And moreover, I'm going to be instructing the jury that they can't consider the other half of the call as substantive evidence. I think I have to, under the hearsay rule.
Your Honor, I still believe that we need to have the call through a witness. If they were to call the person who testified, the person who's on the other half of the call, then we would have the right to cross-examine them about the content of the call. And we don't know what that evidence would be. There may be more to this call or more context to this call that the other that the individual can explain. By just randomly playing calls, we don't have any opportunity to cross-examine anyone or do anything with these calls, and then the jury just takes these calls as without an opportunity for us to put in any explanation about these
Yeah,
calls.
I feel like you're intentionally ignoring the fact that I'll be instructing the jury to not consider the other half of the call. But I understand your position, and you have to acknowledge that you have the power to subpoena the people on the other side of the call if you want to. But let's stay focused on the half that the jury would be allowed to consider from each of these calls, and that's your client's own statements.
I need a moment to look at this call again. I haven't looked at it in a couple of days. Is that all right?
Of course.
It might take me a minute.
Can I see it at the same time? There was something that was on the screen just now.
Yeah, so.
I've got it
Send this to Scott.
Maybe it's just the transcript from the county. Oh, I got it. Never mind. This is just the transcript.
Oh, I see. I'm sorry.
No, it's not it.
It's from court.
They sent it to us the other day.
We're getting it to you.
No problem. And then somebody else on your team is going to provide me and opposing counsel with the transcript of Ms. Gibson's testimony.
Okay, I'm
regarding-
confused.
Yeah.
I was getting you that you want to see the exhibit itself first.
Forgive me, somebody flashed it. I think Katie flashed the content of the call on the screen. And so if Ms. Lewis is looking at it, I'm going to be in the dark if I don't see
Okay,
it at the
Scott,
same
can you
time.
publish the content of the call? And then we'll,
We'll go to the next piece.
gotcha.
Thank you.
Let me just play this portion, Your Honor, without the audio.
Do you have a written representation of what's being said?
It's at the bottom.
Oh, I see.
It has the scrolling text at the bottom, Your Honor.
Let's do it. Give me 1 second. We'll all be on the same page here.
This is just the call.
Cool. Hi.
Did we lose audio, Scott? It would appear that way.
I turned it off. I wasn't
Oh,
sure if
okay.
you wanted
No,
the
that's
audio.
okay. I misunderstood.
We can't see it.
That's true. I can fix that.
Thank you.
All right, Scott, if you would play it without the audio for a moment, I'd appreciate it. appreciate seeing the content of the call. Thank you. Forgive me, for the record, and so that defense counsel can respond. The probative value of this is...
Your Honor, it goes to Ms. Richins' state of mind. It goes to her intent about the marriage and what her thought process was in seeking counsel from a divorce lawyer.
Okay. All right. Ms. Lewis, I understand defendant's position regarding hearsay. Anything further regarding foundation or 4010203?
Yes, I think that the call needs to be further redacted. I mean, I stand on our objection, but if the court's going to let it in, it needs to be further redacted. The first part of the call is not relevant. I'd have to pull it up again, and I can work with them about the parts, and I think the last part. So I think there's some at the beginning that needs to be taken out and some at the end that needs to be taken out. If it's going to come in.
Specific?
On what basis?
Well, if I have it up in front of me again, I can be.
Well, let's have a larger discussion. This was on my to-do list, not necessarily for today, but I've been waiting for defense counsel's final word on the jail calls pursuant to the pending motion regarding the jail calls, and I don't have it yet. At some point, I'll need defense to say what their position is regarding each of the proffered jail calls.
Okay.
So this is the one that's coming up now, but at some point we have to come to closure on that issue, so we're not
Understood.
doing it in real time. How do you want to proceed from this point on this call?
If I could just maybe look at it with the state and point out the first part and the last part and see if we can agree that that needs to be
That's
out of
fine.
the call.
Okay. Do you want to do that now, Mr. Bloodworth, and then address the other issues? Do you want to do that now and address the other issues during the lunch break?
Well, Your Honor, I think the other issues are going to come up way before lunch.
Understood. Okay.
So, let me, if agreeable, let me propose maybe Ms. Lewis and Ms. Shervinack could address that in parallel. Me and other defense counsel can address.
We're fine with that.
Okay. Among the defense team, who is taking lead on Mr. Wright and Mr. Case?
That would be Ms. Nestor.
I have Mr. Wright, Mr. Ramos has Mr. Case.
Perfect. Sounds like this will work. Okay. Ms. Lewis, would you work with Ms. Shervinack to see if you can reach agreement regarding some further redactions to that particular call, 2-95D?
Yes.
Okay.
And just for the record, though, we're not withdrawing our objection, but if it's coming in, that's what we're going to talk about is this redaction.
You're not withdrawing any of your objections.
No,
Right.
we're not.
I understood.
All right.
Yeah. Okay. So, Mr. Bloodworth, the state will be calling Kouri Wright and Josh Case today, correct?
Correct.
Pursuant to the court's ruling in order denying state's motion to reconsider and admit excited utterance, there are portions of their proffered testimony that have been excluded by the court. There are other portions, though, that I imagine the state's view is should come in
Correct.
under other exceptions to the hearsay rule. Have you, can we just talk about practicalities for a second, had a conversation with Mr. Wright and Mr. Case so they are aware of the limitations imposed by the court?
Yes, Your Honor, I've had that conversation with each of them, and to reinforce it during the examination, I will ask questions kind of in the form of, without saying what Mr. Richins said, you know, what was your impression?
Okay. Will the state be eliciting any testimony about statements made by Eric to either of them?
No, Your Honor. The state will scope its questions to elicit responses about what was their impression of Mr. Richins' demeanor and what, if any, advice did they give Mr. Richins?
Okay. Ms. Nestor, that creates a pretty good safety margin between where the proffer started, and it sounds like where it's coming in terms of making sure that the witnesses don't unintentionally say anything that's excluded by the court. Anything further on that issue?
No, sir.
Mr. Ramos?
No, Judge.
Okay. All right. Okay. That handles that. When's the next time a jail call is going to be offered by the state to your current expectation, Mr. Bloodworth, understanding that this is dynamic?
Your Honor, the next time I anticipate
Sitting here today
right now
Yeah.
is during Detective O'Driscoll's testimony.
That was my expectation as well. When's he taking the stand?
Your Honor, he will be most likely the state's last witness, probably late Monday, early Tuesday.
Okay. All right. And so the reason we're doing this call now is for proximity to Ms. Bramwell's testimony?
It is, Your Honor, and the state appreciates that the broader set of jail calls is unresolved and kind of anticipating this. We emailed this 2 days ago to defense to kind of
Okay.
start the process of resolving it.
All right. I'm going to give Ms. Shervanek and Ms. Lewis an opportunity to work for a few more minutes. I'm going to use the restroom. So we'll come back at 10:15.
Yes,
Any
sir.
objection, Ms. Nestor?
No, sir.
Okay. We're in recess until 10:15. Thank you. Redactions to 2-95D. Ms. Lewis, were you and Ms. Shervanek able to reach an agreement?
We reached a partial agreement.
Okay. Tell me where we stand.
They're going to redact a few lines out at the end of the calls, which, I don't know. We agreed to redact the things at the end. At the beginning of the call, I believe we should redact everything up until page. Do you have the transcript?
I don't.
I can send it to you.
Sounds good.
If
One
that's
moment.
helpful.
Yeah.
And Judge, so you know, there have already been some redactions made previous to this discussion for other things that were irrelevant, so those are included already. But you will see some redacted portions of that transcript.
Okay. Whatever you're sending to me, will you copy Ms. Lewis? Or
I have it.
The same thing at the same time.
Oh, I already sent it to you, and she has it that I
Okay.
sent earlier. It's the same.
Got it. One moment, please. Ms. Lewis, if you would just state page and line numbers from the beginning of the call that you think should be redacted.
I believe it starts at page 2. I believe we should redact starting line 15 on page 2 through line 4 on page 3.
Is that it?
That's it.
Okay. I'm not sure that short period adds anything, provides any context, has any probative value. What am I missing? Ms.
I
Shervanek?
disagree, Judge. For starters, it does directly from Ms. Richins say what her state of mind is going into this call, her annoyance, and in her tone of voice when you hear it, when you hear the audio, there's frustration there, and it does add quite a bit of context, particularly in the beginning of the call. And then, in particular, she says on page 2, starting at line 21, I'm just like so fucking annoyed, like what the hell does anything have to do with anything? And that gives context to the rest of the call, because what she's referring to is what does Eric having what does Eric consulting a divorce attorney have to do with me consulting a divorce attorney? Well, she goes on to explain, but that sets up the context for the rest of the call, in addition to her frustration, annoyance that's heard in her voice as well as in her words at the beginning of the call, giving context to the rest of the conversation.
Ms. Lewis, go ahead.
Your Honor, I disagree that that's necessary. I don't think the beginning of the call gives any context to what they're talking about. And if the state just wants the jury to know she's annoyed, she says it numerous times throughout the call. At the beginning of page 4, she says, like, what the hell? I know. I just, like, am so annoyed by that. She says it numerous times. And yes, you can tell by her tone of voice that she's annoyed. I don't see that the beginning gives any context whatsoever.
Yeah, I guess that's my question, Ms. Lewis. Why aren't we just starting at page 4, line 1?
Well, actually, I think that would make perfect sense. And when Ms. Sherbanek and I were going through this, I actually had asked for more to be redacted, and I compromised a bit. But now that you've reminded me, yes, I actually think it would make sense to start at page 4, line 1.
Where, out of the gate, Ms. Sherbanek, she describes being annoyed, and we go from there.
I disagree, Your Honor. She's talking about the Heber thing on page 3 at line 5. She says, beat around the bush. Obviously, what I'm thinking about, she's talking about the Heber thing.
The Heber
goes
thing is
both ways.
different than Ms. Bramwell and Ms. Miller.
No.
Tell me how.
The Heber thing directly refers to her meeting with Ms. Bramwell in Heber.
Oh, I don't think that's clear from the text of the call. If I was confused about it, I think there's a pretty good chance the jury would be confused about it.
I disagree.
I know, you've been very clear about that. Anything else?
Just that this is important context for the whole call, and starting it partway through does not give the context that's necessary to understand what starts on page 4 at line 1.
Anything else?
It's relevant, Your Honor.
I understand. Anything else?
No.
Okay. We're going to start the call at page 4, line 1. Anything else, Ms. Lewis?
No, Your Honor.
The court rules that starting the call at page 4, line 1, and then including the redactions that counsel have agreed to in the body of the call and at the end, provides probative information regarding Ms. Richins' state of mind and backward-looking reflections regarding her consultation with Ms. Bramwell. That probative information, probative value of that information is not substantially outweighed by the danger of unfair prejudice or any other Rule 403 considerations. With respect to defendant's hearsay objection, Ms. Richins' side of these recorded calls is categorically not hearsay, and the court will instruct the jury that they cannot consider the male voice side of the call for the truth of the matter asserted. Rather, they can only consider the statements made by the male on the call for the effect that they had upon Ms. Richins in the conversation. Any further objection, Ms. Lewis?
No, Your Honor.
In terms of instructing or just providing the jury for context, I'm inclined to tell the jury that Ms. Gibson testified that she preserved some recordings of phone calls involving Ms. Richins. You are about to hear one such phone call. Any objection, Mr. Bloodworth?
No objection, Your Honor. Are we good then to, as we discussed at the bench, have Ms. Sherbanek just give the date of the phone call?
No, Your Honor.
It's not in the content, and Ms. Gibson didn't provide that particular piece of foundation, so that would be additive.
Your Honor, if we were to play that portion of the audio of the jail call, it would make it clear that it was a jail call.
Oh, forgive me. I haven't heard or seen the introductory portion of the home wave call. Does it?
Right,
does
Your
it
Honor.
state the date?
Yes, every home wave call begins with a time or date, and then this is a recorded line, and anything you say will be preserved, could be monitored, and admonishments like this.
Is accurate, Ms. Lewis?
That's accurate, but this takes me back to my initial point, is this should have been, and typically would be, introduced through a witness, because the witness could have just said the date and we wouldn't have this problem. I don't think that the state should be testifying to the date.
Right, but if Ms. Gibson had just said, in order to avoid playing any of that for an indisputably authentic call, I will custody in front of the jury, I think it's in fair and necessary balancing to not play the preamble of the call, which would limit your ability to cross-examine Ms. Gibson as to how she knows when the date of the calls, because it's based on that same content. And so I think it's appropriate and does not violate defendant's rights in any way to just state what is undisputed. December 18, 2023, correct, Mr. Bloodworth?
Oh, that's correct, Your Honor. I also think the date falls, because of the way the calls are labeled, the date falls under Jeremy Thomas's certification as to the authenticity.
I understand. I think you and I see it the same way. It's just a matter of the defense's good faith objection to me providing the information, but given the alternatives, this is the best way.
Yes, sir.
Okay.
One more
Please.
pragmatic
Yes.
question. Because the court's decision just redacted out the initial part of the demonstrative, it seems to make sense to the state to, at this point in time, as a matter of efficiency, to just kind of fast forward and hit play beginning at page 4, line whatever the court
Line
just
1.
decided,
Yeah.
rather than take 15 minutes to redact the exhibit now, and then at the end of the day we can redact it and clean it all up consistent with the court's ruling.
Is Lewis, you okay with that? You're not waiving any objections?
Yeah, I understood. Yes.
Okay.
I've got it redacted already, ready to go. Page 4, line 1.
Okay, so Scott's way ahead of us.
All right. Scott, why don't we take a look at it together? Show me the new version of 2-95D. Well, the text is correct. Scott, let's try the audio.
Your Honor, we can't see it. Here.
My apologies. Oh, Scott, go ahead. Yeah.
Obviously.
Who fucking
What
cares?
the hell? I know. I'm just so annoyed by that. I'm what the hell are you talking about? Who gives a shit?
Yeah.
Obviously, if
Yeah,
one
it's
party's
not like-
going to do it, the other party's probably
Okay.
going to do it and see what the fuck.
Do you want to fast forward to the end just to confirm, so Ms. Lewis can confirm that the stuff at the end has been redacted out?
I'm sorry, Your Honor, I did not catch anything for redactions at the end.
Okay, I can.
Yeah, if you would work with Scott real quick to make sure that the stuff at the end gets redacted out.
Yes.
Thank you, Scott.
Hey, you used to say it's redact. It's the way it's being offered includes redactions. Yeah.
Okay, Your Honor, I have this ready. If everybody'd like to do it again.
Let's do it. Table 2. Okay, if you fast forward to the end, Ms. Lewis, let's make sure that the redactions you spoke with Ms. Shervinack about have been made.
All right, I have the audio on my speakers. Let me change that over real quick.
Okay.
Obviously.
What'd she say no to?
So yeah, I don't know.
They found, like you said, they found out about it, but guess what? You know, so did he.
Exactly.
So it's everybody's natural reaction to want to
Yeah.
defend themselves.
That's correct.
Okay. Give me one moment. Okay. Mr. Bloodworth, Ms. Shervinack, anything before we invite the jury back in?
No.
No, Your Honor.
Ms. Lewis, Ms. Nestor? Okay, we're ready for the jury.
All right.
Please have a seat as you come in. All right, folks, have a seat. Thank you for your patience. Ladies and gentlemen of the jury, when Ms. Gibson was testifying, she testified that she downloaded and preserved recordings of certain phone calls involving Kouri Richins. You are about to hear one such phone call from December 18, 2023. You may consider Kouri Richins' statements on this recorded call for any purpose. You may not consider the statements made by the male voice on this phone call for their truth. Instead, the only purpose you can consider the statements made by the male voice on this phone call is for the effect it had upon the listener, that is, Kouri Richins. Scott, let's make sure we are ready to go. Okay. 2-95D is admitted. Please proceed.
Obviously. Obviously.
Who fucking
What the
cares?
heck? I know. I'm just like so annoyed by that. Like I'm like, what the hell are you talking about? Like who gives a shit?
Yeah.
Obviously, if
And
one
it's
party's
not like-
going to do it, the other party's probably going to do it to see what the fuck.
Right? And it's like,
Like common sense.
you know, regarding your side of stuff, nothing came out of that. What came out of the other side?
Exactly.
Oh, an illegal transfer of everything.
Yes,
Like,
exactly.
A lot came out of that.
Yes, I just went in for a consultation. That was it.
Yep.
So why is that so bad? Am I misunderstanding something?
No, it's just something they're going to try to probably try to hold against you, you know, for no fucking reason. Because
He did it first.
guess what? Someone else, yeah, he did it first, and not only did he do it first, like he actually took action on it illegally.
Yes. All I did was, what the hell am I supposed to do? That was literally the conversation.
Yeah. Yep. So
Which is my
you know,
right to
that
do.
person's probably going to be right.
And
So that
it's-
person's probably going to be brought in,
Which is perfect, because you know what I told that person?
which is well,
I don't want to fill out the packet. I don't want absolutely anything. I want to walk away clean and free. I don't want anything. And she kept advising me, no, that's not how this works. You have to fill this out about da-da-da-da. And I said, I don't want to. I don't want any of it.
yep.
That is what I told that lady. I said, I just want these done. And
Yeah,
she
so
argued
perfect.
with me. Forever. I took the packet, I threw it away. I'm like, no, I won't fill this out. Because I don't want to have
So-
everything.
I mean, right. So that's perfect and works in favor for you for everything.
Yep.
Nothing,
Yeah,
you know.
I'm just like so fucking annoyed by it though. Like, quit portraying me to be this person.
Yeah.
Anything you're trying to say I did, Eric did. Like, so now they cancel each other out, you fucking idiots. Like,
Yeah.
protecting myself, like,
Yeah, I wouldn't get I would get too worked up about it.
yeah, I'm not, but that just gave me an idea. I am going to ask if she can testify.
Well, that's not really going to matter because she just gets subpoenaed. And to be honest, if their attorneys don't do it, yeah, you're going to.
Yeah. So I don't know. I'm just annoyed. So I told Mom. I said,
Because they're going to try to paint this picture. So you're going to try to paint this picture and like, oh no,
yeah.
no, here she is. What did she ask about? What did you advise her? What did she say no to?
So yeah, I don't know.
They found, like you said, they found out about it, but guess what? You know, so did he.
Exactly.
So it's everybody's natural reaction to wanting
Yeah.
to defend themselves.
Counsel, the state's next witness, please.
Becky Lloyd.